exploring the complexities of election laws and their impact on democratic processes.
To understand what's going on with the election debacle between Mr. Buchanan and the Constituted Authority. I need you to understand this, that it's not between Mr. Buchanan and the Prime Minister. Prime Minister is not a party to this lawsuit. It is between Mr. Buchanan and the Constituted Authority, the entity that said, we are not forwarding your petition or your complaint to the election court because we don't think that the evidence is worthy enough. We don't think you can get a conviction on this. They weighed the evidence. And so we were hoping that Mr. Wildman would join us today to talk about that aspect of it. But our aspect of it is to just show you the two laws. And believe me, you're going to be experts at this before the end of this hour. You are going to be expert at this. All right? Let me show you. Get your pen and paper ready. Get your pen and paper ready. Here we go. If ever there was a class where we are going to teach, this is the one we will teach, right? Because a lot of you, I know, don't have the time, and a lot of you don't have the inclination, and a lot of you, you read this stuff, it's going to read like a foreign language to you because of the way it's written. It's not written in a way that, some of it is not written in a way that's easily understandable. And that's where we come in. It's our job to make sure that we educate our people. Here we go. What we're going to do now is we're going to show you the two laws at play in this election case between Mr. Buchanan and the Constituted Authority. The judge said that Mr. Buchanan filed an election petition. All right, let's start here. We're looking at the Elections Petitions Act. This. See that? You see that date? 1885. There it is. That's when it was established. And over the years, they have changed it, bits and pieces of it. It's still in effect, but they've changed it. They've repealed certain things and added certain things. One of the things that they did in 1997 was they mentioned section 35 to 38 of the EPA. I think, yeah, it's the EPA, section 35 to 38 of the EPA. That came into being in 1997. And in that section, they talk about election court and this and that. But let's go before 1997 and get you updated. Here's what happened. Let's start right here. You have an election. And when you have an election, you have a winner, you have a loser. I mean, we all broke this down now to the bare essentials. Everybody's going to understand it. You have a winner and you have a loser. The loser, under this law, the loser can then say, you know what? I don't like what was done. And so I'm going to file in court to say that they robbed the election from me and we should have a do-over. Okay, that law, here's what it says. It says a petition, you have to file a petition. Under this law, you can only file a petition. And here's what it says. It says complaint of undue election or return, meaning the election or itself or the person being declared the winner. Here's where it must go. It must be presented to the Supreme Court. We are going to show you that Mr. Buchanan did not file a petition in the Supreme Court. So therefore, it cannot be an election petition. It cannot be this. It cannot be that. That's first requirement, that whatever you're filing under this law, the Elections Petitions Act of 1885, that it must be filed with the Supreme Court. That's one. Second thing is that when you file this report that you're going to file with the court, it must state in general terms why you're challenging the election. And you must say what you want. Here it is, and the relief being sought. So you need to do two things with this thing. You need to state in general terms. So you say, oh, I felt intimidated. Or, oh, I couldn't go because, my dog died. Or whatever it is. You have to put that in the document. Another thing that you must do with this petition, you must provide a security deposit to the court at the time of filing or within 3 days after. So when you file this report, you have to put up some money. And the money is to pay costs and expenses for your witnesses or court costs, all of that stuff. But you have to put up your money. That petition must be signed. And you must file it where? The Supreme Court. Next question. Who can file this document? Who can file this election petition? The clerk of the House of Representatives can file it if she get the concurrence of the House. If the House members say yes, we'll go ahead and file it. Clerk can file it. Who else can file? The Attorney General of Jamaica can file. Who else can file? This is key. See it right here? Anyone can file an election petition. So you don't have to be the losing candidate. You can be a person who believes that the person lost because there were shenanigans going on. And you can go and file it. And you file it where? Supreme Court. And you have to state the general terms. I'm filing it because I saw a man running off with a ballot box, and I saw them burning the ballots or what. You have to file it, and you have to state in general. You don't have to get specific, just in general. And I'm skipping out some stuff here because, for example, it says you can file in general, but when you notify the winning candidate that you're filing the lawsuit, you have to give him specific. You have to give that person specifics. So you can say, hey, you can say to the court, all the ballots weren't counted, and you tell the court that. So I want a hearing. But when you have to serve the winner because you have to bring him come to court. So when you serve your papers to him, you have to say all the ballots weren't counted because they were destroyed. You see the difference? One is just general. The other one you get very specific. They were destroyed by two men wearing whatever. And here it is. Anybody can file. It can be filed by Attorney General. Can be filed by the Clerk of the House of Representatives. Next question. When do you file? You must file it within 21 days after the election. If you file it 22 days, you're late. There's a provision for 28 days, but that is only relating to corruption. In general, it's 21 days. The only time you can file 28 days is if you're going to say, well, the winning candidate, I saw him giving people money for them to vote. That would be considered corruption. And then if that is your claim, you have 28 days. But if you don't have a claim of corruption, it's going to be 21 days. So for example, if you say, when they came out, we were supposed to go a certain route and they didn't go that route. And as a result of that, I want a do-over. That wouldn't be corruption. That would be a violation of the rules, but it wouldn't be corruption. Or if you say, a gunman came into the center and chased everybody away, and so we couldn't vote, that my people couldn't vote, that wouldn't be corruption. So for those claims, you would have to file within 21 days. Corruption, where you're paying somebody to vote, for example, that is 28 days. Get the difference? And next question, what about the trial? Let's say I do all of this. Let's say I file it with the court, I put up the security deposit, I notify the winning candidate, I sign it, file it, all of that. When is the trial? When we go to court? Here it is. The trial must be conducted by one judge, only one judge. Go and listen to it. And it must be done within 20 days from the time you file your petition. So here it is. You must file your petition with the court within 21 days of the election. So you can file it on the 20th day. The clock starts to run for the trial the day you file. So if you file it, let's say after the election, you file it on the 10th day, then the 90-day period for the court starts to run on the 10th day, the day you file. It's the 90-day period does not have anything to do with the election directly. It's when you file. You trigger the court mechanism. You trigger you initiate. Your initiation will cause a judge to be assigned and the matter be heard. So if you file it on the 22nd day and it's not an issue related to corruption, then the judge is not going to listen to your matter. Because once they look at it, they say, but wait a minute, this is corruption. It should have been, or if the judge even listens to it, he's going to say, I can't listen to this because it's corrupt. It's not corruption. And let's say it's not corruption and you mistakenly thought that it was an issue of corruption and you file 27 days. The judge is going to say, but wait a minute, you're 6 days late. You should have filed on the 21st day because it's not corruption. But there it is, people, in a nutshell. Now, here's what happened with this same law, 1885 law. In 1997, they had some sections right here, 35, this one, 35 to 38, right? And here's what it says. It says 35 to 30. It says, we now recognize that there's something called an election court. Because remember, down here, where you go? Right here, you go Supreme Court.
Supreme Court.
Right. Now they're saying in this section, there is an election court. And instead of one judge right here, it's now 3 judges for the election court. And they said, here, the trial must be had within 90 days of the filing of the petition. They said this election court is going to last 6 months from the date of election. So this court is going to be in existence for 6 months. Then it disappears until the next election. The procedure is that the election court comes into being on the day of election. and 6 months after. And look at this. Remember down here, I said that who can file? Anybody can file, including the Attorney General and the Clerk of the House. Look up here. Who can file? Only the constituted authority. And the court will only listen to this, an election notice application. And who can submit that? Constituted authority. These people right here. And remember what I said for the election petition, how do you write up what happened? And they say you write it in general terms. You just put, the ballots weren't counted. That is what you tell the court. No, when you write, when you tell the winning candidate that, look, me I take you go to court because, we want to do this thing over, or you take whatever body it is, then you have to be specific. You have to tell them that the ballots weren't counted because I saw this man with a ballot box and he ran down the lane, and when I followed and I looked, I see him take out the ballots and then he lit them, ballot burner. You have to give them specifics. But for the court, you don't do that. Look here now. Now it changed. You have 5 grounds. You can't just come in and just say generally what happened. You have 5 grounds. The first one is that we have more votes than voters. When we open the ballot boxes, we say 100 ballots in there. And when we look at the voting list, we only have 75 people. So 25 people, 25 ballots are in the box that shouldn't have been in the box. That's one. Second one, the ballot boxes were stolen, destroyed, or tampered with. Third one, the presiding officer signed the ballots under duress because he have to sign off on them. And somebody put a gun to him and said, sign off on them. Sign off. The fourth one, some people who voted, they're not bona fide electors. That would go to number 1. Where it says the votes, you have more votes than you have voters. More people voted than people on the list. And this would go to that. Number 4 would say votes cast by individuals who are not bona fide electors. So what this tells me is that if you vote twice, the first time you're a bona fide elector, the second time you're not. Because remember the principle, 1 man, 1 vote. Same man, same vote. And the last one is that there were violence and this is the key right here, irregularity on election day that results in a substantial distortion or subversion of the process of a free and fair election. All this means, people, this is similar to going back to one where they say you describe it in general terms, but here's what this is saying. This is saying something happened that cast doubt on the election being free and fair. Something happened. And that something could be when the ballot boxes left the polling stations, they were supposed to go to the counting station and they were supposed to follow a certain route. And then and they didn't allow us to stay in the vehicle with the ballot boxes. And then when we were supposed to come out and go right, and they come out and go left and we had to follow them, and then we lost them. We didn't know where they were. That is an irregularity that cast doubt on the free and fair election. Another one would be, they had a whole bunch of people gathered in front of the polling station wearing a certain color and threatening us. We were wearing certain colors as well for the opposing party, and they threatened us and said we can't vote. If you look, that doesn't fall under 1, doesn't fall under 2, doesn't fall under 3, doesn't fall under 4. It would fall under 5 because they consider it an irregularity that would cast doubt on the election being free and fair because they're preventing people from voting. So this 1885 law, they amended it in 1997 and they added this part to it, 3538. So they recognize that. Now let's go to the second law and let's go down, start right here. You have the election again. Election. Losing candidate must do what? You must file an application within 40 days after the election. Remember this one up here? You file it when? 21 days. So this one is 3 weeks, them give you to file. This one, them give you 2 weeks to file. But here's who you file with. You file with constituted authority. There is no Supreme Court here. So you file within 14 days of the election with this constituted authority. And remember the 5 things I just told you about. I just showed you. Those 5 things, you enumerate them. You write them down. You can't just make it general. You have to make it to fit one of those 5 categories. So within 14 days, you file it with them, right? And then they have 28 days within which to send it off to the court. So you have 2 weeks to send it to them. But here's the thing. You have 2 weeks after the election. They have 4 weeks after the election, not 4 weeks from the time you file. Remember, we go up here and we say, we show you this one, right? And we say that the judge is going to do it 90 days within from the filing of the petition, right? You file within 21 days of the election, and they file 90 days based on when you file. This one is different. This one is say, we don't care when you file. We are going to do it. We are going to say you must file your application. We are going to file it with the court within 21 days of the election, not 21 days after you file. 21 days, 28 days after the election. So you see that the timelines get tighter now because you have only 2 weeks after the election to file it, and they have 4 weeks after the election. So let's say you file it on, let's say the 14th day. So you took your 2 weeks. If you believe that, 28 days, that's 4 weeks. So I have 4 weeks from the date, they have 4 weeks from the date I file, you would be wrong. Because why? It's 4 weeks after the election, not when you file. It's a shorter period. And so when they send it to the constituted authority, the constituted authority send it to the election, they send it not to the Supreme Court, to the election court. The election court must have a hearing within 60 days after it is filed with them. And watch here, court must issue a judgment within 2 days after the hearing. Up here, there's no such requirement. They just said the judge must have a trial within 90 days. When is he gonna make his decision? We don't know. We don't know. So, and then I just put this up there as a reminder. This one right here. No, sorry. This is the second law, the Representation of People Act, 1944, right? And the section that we're concerned about is section 52A. The second law is the Election Petitions Act of 1885. And just as a reminder, this is what it says, that this election court, and if you notice, the election court was not defined in the Representation of People Act. It's not defined there in the new law. It's defined in the old law in 1997 when they changed it. And by the way, 1997 was the first time Andrew Holness competed for representational office. 1997, December 1997. And here it is again, 3 judges, petition, 6 months from the date of the election, the court will dissolve, and you must state the basis, and here are the 5 bases. So here it is right here. Now, here's what happened. The judge started talking about an election petition. Mr. Buchanan did not file an election petition because an election petition can only be filed with the Supreme Court. He didn't file with the Supreme Court. He filed this one. He filed with the constituted authority. And what she started saying, she started getting everything confused because she's saying, even though he filed within a reasonable amount of time, it didn't give the court wouldn't have enough time because then it would be the 28-day period would have expired. It's a whole bunch of nonsense. It's a whole bunch of nonsense. Here's what the law doesn't say. And here is where the legal minds start split hairs, right? The law doesn't say what is going to happen if the constituted authority rejects your application. The law doesn't start to talk about, well, if it's rejected, what about, because if you file it, right, on the 14th day, remember, no, they have 28 days after the election, not when you file it. So when you file it, they have 2 weeks. So let's say you file it and they come back and they give you, they reject it. No, you really can't go back to them because they've rejected it, right? And by the way, remember, you can't file with the election court on your own. These people have to file it for you, the constituted authority. So what the judge was saying was that if they got turned down and the time period to get it to the election court expired, or would have expired, because they went to the Supreme Court seeking relief. Because you can go to the Supreme Court to seek relief. So the law doesn't mention anything about what happens if you file and it's rejected. And let me show you something. Hold on a second. With the 2 laws, Kevin, one of 52 and one of 3538, 52A. Let me get where the 2 laws there. Okay, here's the election petition. Oh, wait. No. Okay, here it is. All right. Remember I told you about the Election Petition Act. And let me just go up the just to not trick nobody to show you. Here it is, the Election Petitions Act. And let me show you. Now try to trick you. Here it is. 1885, and here is the 1997. That's the amendment. That's the one we're talking about. And if you don't believe me, that's fine. I'll show it to you down here. Here it is. The law passed, but see? Amended 1997. See, it's right there, 35, right? And here it is. It's telling you what the election court have to do. Now, remember, this is the same law that says you go to Supreme Court, right? It gives you 2 options here. And here's the first one. Here's the first one. Hold on. Here it is right there. A petition may be presented to the Supreme Court. It's right there. Who may present petitions? Supreme Court. And here it tells you who. Clerk, right? Attorney General. And look in B. look in B, look at the last part of B. It says by the Attorney General or, oops, I'll go on there. Okay, here we go. All right, here it is. Or by any other person, B, right? So it gives you that option. And then watch here. Let's look at the dates. Let's go back and look at the dates. That option was given to you in 1963. See it right here?
Provost, you see somebody just joined us?
Oh, hey, Mr. Wildman. Mr. Wildman. Don't bring him on. Brother Hugh.
How are you? What's going on?
We can't see you though.
You can't see you.
I'm actually coming from the gym, you know. So
I know.
Man.
Show off, you come show off and we, you know. See,
no, man, no, you take
you show off with the muscle, but that's all right. No problem. All right. Mr. Wildman, what I was doing was I was just explaining to our audience, to our beloved people, about these two things. I was going through, I went through the Election Petitions Act to show them the requirements, right?
Yes.
Show them that it was a Supreme Court, but that in 1997, that added section 35 to 38 that mentions the election court.
Yes.
And then I showed them all of this stuff saying in the Election Petitions Act, anybody can file it. You must put up a security deposit.
Yeah.
It must be general terms. You must file it within 21 days, except in the issue where there's corruption and it's 28 days. Trial done by one judge within 90 days of the filing.
Yes.
Then I brought them over to Representation of the People Act and showed them that here they talk about the time period. Losing candidate must file within 14 days after the election. The Constituted Authority must file within 28 with the election court 28 days of the election. And the court must have a hearing within 60 days of the filing of the application and must issue that judgment within 48 hours.
Yes.
Told them that, listen, the problem here is that the law doesn't say what happens. It doesn't specify that if you're rejected by the Constituted Authority, here's what happens.
Yes.
Right? It kind of presumes that everything is going to go and
that's correct. Yes.
All right. So now I'm glad you're here and I think you time it right because we only have 28 minutes left. But what I would like for you to do now is if you can just talk to us now about what Mr. Buchanan did under the Representation of People Act, as opposed to what the judge is saying that he should have also done under the Election Petitions Act.
Well, Mr. Buchanan did what the law says he can do under the Representation of the People's Act. He made the application to the Constituted Authority for them to intervene and to send the matter to the election court, as opposed to the election petition, which you go straight to file a petition challenging the outcome of the election. And that's a different regime. This is a more modern regime that, based on the history of elections in Jamaica, the parliament of the country felt that there was a need to act swiftly after elections, even during the election. And so they devised a mechanism whereby you can go straight to a body, and that body acts as a sifting process and determine whether election should be voided by reference to an election court set up under the Election Petition Act. So that is the difference in the regimes. One, you go straight to election petition formally. Now you come to under the Representation of the People's Act, the Constituted Authority, set up under Section 44. And you have, once you show them that there are circumstances that warrant the intervention of the election court, then they should send it to the election court.
So, let me just put this up here. We did this on Monday, but I need to put this up because, again, folks, this is a case where the prime minister, where he wasn't prime minister, was a candidate, and he ran against Mr. Blake, and the similar thing happened, and so they went right here. They went to the election court. Here it is, right here. They went to the
because on that occasion, the Constituted Authority was the one who made the referral to the election court. They, on their own volition, they thought there was a need to go to the election court, so they referred it to the election court on their own motion.
Okay. Now here is something, because Mr. Andrew Holness at the time objected to it because he said it was a petition, and he said one of the things that Mr. Blake Mr. Blake didn't put up the security deposit.
And they rejected that notion because this is not an election petition. This is a new regime set up under the Representation of the People's Act to void election. So that argument did not find favor with the court.
Okay, sir. All right. Let me just put it up to the people. All right, here it is. That section 40, Mr. Holness was saying that, here it is, that section 4D was not complied with.
Yes.
Because the security payment for the cost had not been given.
That is
and
correct.
therefore It was, it couldn't stand
because
because he's arguing.
they were trying to treat it as a petition, election petition, when it was not.
Exactly. And here is what the court said. The court, let me get to it quickly.
Rejected that argument.
The court said, I find the submission untenable.
Yes.
The motion to void an election clearly is not an election petition.
That's correct. These are new.
The court went on to say, and this is very important language. Yes. The court went on to say the voiding of an election is a new, different regime created by the recent amendment to the Representation of the People.
And I pointed out that in the submission before the judge. I pointed all of that. That was presented to the judge.
So, Mr. Wyman,
all of that argument was presented to the judge by me.
So, what went wrong?
I am baffled myself because all of that was put to the judge. That this is not an election petition. This is a new regime, which was identified in the Blake Hollis and Blake case, and they rejected the argument that they should be treated similarly. They are two different regimes. So that argument was put up by me.
Some people, and I tell you, I've gotten calls from attorneys in Jamaica. They don't understand it. They've read the opinion, yes, and they're saying to me that, hey, this opinion sounds like it's sound legally. And I said, no, it's not.
Can't be sound.
What do you say to somebody like that? Somebody who's steeped in the legal profession, but they're not aware of these two laws.
They may not be knowledgeable about these things. So people can be lawyers, but they are not knowledgeable about these things. So until you have satisfied yourself in terms of the learning, you may be fooled into believing that it is the same thing, but it is not.
No, on Monday when we had the discussion, we would ask what's next, and you said, well, we're willing to go to if need be, we will go to the Privy Council because this is a matter that must be resolved at the highest levels.
That's correct.
Where are we with that right now? I know that you said that.
Yeah, the application to go to the appeal court has been filed, waiting on a date from the Supreme Court to hear that application. Once you see, because it's an interlocutory matter, you have to get leave to go to the Court of Appeal. So that's what we're trying to do right now. So once we get that leave, we go straight to the Court of Appeal to argue the case on an appeal.
No, when you get to the school me here, when you get to the Court of Appeal, what will be the issue? Will the issue be the decision made by the judge? That just rendered this opinion, or would it be the constituted authority's decision?
No. It will be to overturn the decision of the judge, and also to grant leave to go for judicial review. Right? That is what we had sought in the first place. To get leave, which the judge was supposed to have given us, which she did not. So the Court of Appeal will be asked to overturn her decision and to grant the leave to go to the judicial review court.
Okay, good. Now, how much time are we talking? Because
it should be quick, because we're saying that we have filed already. Once we get a date, that can be heard in a day, and then we go to the Court of Appeal.
And if
the Court of Appeal, we argued for the court to overturn what the judge did.
Right. But
and also to overturn what the Constituted Authority did.
So then will the matter be sent back to the Constituted Authority to send it to the election court?
No.
Where does it go?
We are asking the Court of Appeal to intervene, to grant the leave to go to the Judicial Review Court to quash the decision of the Constituted Authority in refusing to send the matter to the election court. Remember, we asked for mandamus, So the Court of Appeal would be asked to compel them to send it to the election court.
Okay, so it's not going to go to the Constituted Authority. It's going to go straight to the election court.
Well, if the mandamus is granted, they in effect would have to just comply and send it to the election court.
Okay. Now, people have made argument. I won't render my opinion on it. I'll just tell you and ask. I'll just mention it and ask you the question.
Yes.
They've said that the election court, the life of an election court, is 6 months from the day of election.
Yes.
Set up the day of election and then 6 months after to review matters.
Yes.
Talk to us now about going beyond the 6 month period. Let's say, so the 6 month period is going to end March 3rd. Yes. So let's say that all of this is resolved in April or May of next year.
Yes.
Explain to us, how do you survive that argument that the court is no longer in existence? And so what do you do now? Because the 6 months.
Well, if the process is timely because of the judicial process, that cannot be used to prejudice the client. The fact is that if the matter should have been sent to the election court in the first instance, then the election court would have to be convened to accommodate the application if the court were to agree with us that this matter ought to have gone in the first instance. Because as I was saying, that if it is a nullity, then the election court life would not have ended, because it should have entertained the application by a referral from the Constituted Authority had the normal things been done.
Right.
So time would not run against an applicant who successfully challenged the decision of the election of the Constituted Authority in that regard.
Because here is how I read this, right? The way I read it is that all things being equal,
Yes.
these are the timelines.
Yes.
Yeah, I don't read it as strict as some of my colleagues would say. Well, it says 6 months, and I'm saying no, it's 6 months if
6 months when things, if you follow this the letter of the law, 6 months. But if you
Right.
acting on a nullity, in this case, you have established that the Constituted Authority did something that was not supposed to be done by them. Then in law, it will be said that they never made a decision. That's why you're asked to quash it by way of certiorari. They never made one. So if they never made one, then the life of the election could not have run from a certain time.
And here is why I say that.
The life of the court would run from the time when the decision was properly made.
Okay. And here's my take on it, right? If you look at 4, it says the election court shall, within 6 months of the date of the taking of the poll, 6 months after the election, determining all matters brought before the court.
Exactly.
If the matter was never brought to the court, then it can't be 6 months.
That's what I'm saying. That's the point.
So, Mr. Wildman, don't tell me that is only me and you and Kevin and a few other people see it this way. Why is it that people don't see this?
No, because they just look at, they look at the surface of the thing, but not looking at the nuances of it.
It's all about the headlines and not
the
body.
the nuances,
the details.
Well, one of the things we have done, and people, let me just make it be clear, Mr. Wildman did not ask me to do it. I chose to do it because of our mandate. The One Jamaica Legal Defense Foundation is wedded to the idea that we need to hold government accountable. There has to be rule of law, and also we have to protect the sanctity of the election process. Free and fair election, one man, one vote, same man, same vote. And to that extent, I've asked all of you, and like I said, Mr. Wildman has nothing to do with this. I've asked all of you for weeks now to put aside $100 because we would like to support this appeal. And we want to support the appeal, and we want to make it abundantly clear. We're not supporting a party. We're not supporting a candidate. We're supporting the principle.
Yes.
It could have been somebody from UIC, NDM, Up Jamaica, the JLP. We don't care.
Yeah.
Provided, there's a feeling that the process wasn't fair.
That's correct.
We are going to support the appeal. And we made it clear that whatever money we raise, the money is not going to a political party. The money is not going to a political candidate. It is going to the attorney representing principle, representing the interest at trial or at the hearing. And some of you have already started to submit funds. And I'm going to appeal to you now that please send your $100 now or whatever you can afford. I remember what I told you. I said, I'm going to put $200. I need you to send your money. And when you send it to the OJLDF, please indicate on it. It is for, just write the word appeal. Just put appeal. Put appeal, and we will know that this money is earmarked. We have some women now controlling the account, So we have checks and balances, and they're looking. So they're making sure that whatever comes in, and it comes in to support OJLDF, that is set in a separate pot from what comes in for something else, like the relief effort or an appeal. Some of you have started already sending your money in. I'm going to urge, I'm going to suggest, I'm going to plead, I'm going to beseech you to start sending your $100 or whatever it is that you can afford. If it's only $50, a lady called me this morning and said, if it's only $20, me have to go send it come, because I believe in the rule of law. And we cannot have laws violated and we just sit back, because you know what that does? It encourages people to continue breaking the law. Yeah. And we can't do that. So, Mr. Wildman, we only have a few minutes left.
Yes.
Anything you'd like to say to the people here?
Well, it is good that people are really interested in a matter like this, because, as you say, it goes to the heart of the democratic process. And we think that it is not good for us to have a bad decision standing as representing the law of the land. So where we find, as in this case, that the judgment is very, very deficient and falls short of what should have been, I think it is a duty of us lawyers to put it right, get it right. Because we can't allow this to stand as a precedent. And we're saying that there are a number of flaws in the decision which we need to have corrected.
Let me ask you this. What's the I forgot the name of the body that disciplines attorneys, but then there's also one for the judges. Is it the Judicial Commission?
Well, the judges are only answerable to the Judicial and Legal Service Commission. They're the only ones who...
Judicial and Legal Services Commission.
Yeah,
no.
yeah.
Is this something, and I'm not asking you if you're going to do it, but is this something that people who are concerned about decisions rendered by judges, decisions that seem to be baseless, Now, we're not talking about a decision that's close.
That is where you have the Court of Appeal comes in. If something is so wrong, then it has to be corrected by the Court of Appeal.
But can in terms of disciplining the attorney, is there something that regular citizens can
judge?
No, you can't just say that because a decision may be bad that you can say that is a basis to impeach a judge. It has to be something to do with conduct outside of the judgment that is rendered. You may criticize the judgment as met. So if you think the judgment is so wrong, you go to the Court of Appeal and try and set it aside.
That's what appeals are for.
That's what appeal.
Yeah, but I'm talking about beyond appeal, because if
that would not give rise to quote unquote misconduct in and of itself, unless there are other things there.
If there are a series of events along that line, now you can say, all right, here's evidence of a recurrence, and at that point,
no. Even a line of bad decision in of itself does not give rise to disciplinary action. You have to show something like amounting to judicial misconduct.
What does that give us? Give us a definition of judicial misconduct.
I mean, it can take various forms. I don't really want to specify. I mean, I think you can use your imagination here. You don't want me to tell you all of that. But it has to be something that goes outside of the normal judicial process. You get me?
Yes.
Something that would bring the bench and the judicial process
into this review.
Okay. As in affiliations?
Pardon me?
As in affiliation?
Affiliation?
Yes. If
I don't want to get into those nuances. But I think people understand what we're saying here. It has to be something that amounts to judicial misconduct. Not, in other words, even if you think a judge is not competent to the point that, they are giving good judgment, that by itself does not give rise to judicial disciplinary action.
Right. I see in the chat here, African Newbie said bribery would be one.
Most definitely.
And another person said political influence or coercion, but you have to prove that.
How you prove that? How do you prove that?
How do you prove that? Unless you have a tape and somebody has tape recorded, there are three people and somebody taped it.
You'd also have to prove prejudice. So
One last question before, and I know Kevin have a question because we only have 9 minutes left. This is a different question. This is aside from what we're discussing. Is there a constitutional provision or any provision anywhere in Jamaica that prohibits a criminal, and when I say a criminal, somebody who commits a crime while being a parliamentarian, is there a law prohibiting that person from returning to the parliament?
Yeah, the Constitution. If you are given a sentence in excess of 6 months, you can't be a parliamentarian.
Less than 6 months?
Less than 6 months, but in anything excess of that.
Because the reason I'm asking is because Marissa Dalrymple Philibert pled guilty, and
but
I know they fined her, but she was facing prison term.
Well, because that is what the sentence was. Because the Constitution makes provision for disqualification and tells you what are the things that could disqualify you from being eligible for both a member of the lower house and the upper house.
Does it make a distinction between crimes committed while you're a parliamentarian?
It doesn't matter. Once you have not been given a sentence in excess of a certain period.
Okay. Kevin?
The man answer the question. I don't want to get too deep in because we are pressed for time right now. But it's always a pleasure to learn something new or to brush up on something that was missed along the lines. And your direct involvement and willingness to clear up cloudy matters, Hugh, is greatly appreciated. Loved. I wish you all the best. You already stated that you're willing to go as far as the Privy Council.
Yeah.
This timeline now, though,
Yes.
we're looking at the next month.
Yeah, yes. We once we get the leave, I mean, if we, for example, that could be done next week. If we get the date next week, and we get the clearance to go to the Court of Appeal, we file the appeal, then that is a matter of months. Could be a month, could be a month, could be 2 months.
Okay, thank you.
Let me ask you, if let's say you go to the Court of Appeal,
Yes.
and the Court of Appeal rejects your argument,
Yes.
do you have to get permission from the Court of Appeal to go to the Privy Council?
Yes, but even if that permission is denied, you can still go to the Privy Council.
Well, look, Mr. Wildman, I want to thank you for your time. I know that it's been a very, very busy afternoon for you. And you and I will be talking soon, sir. So
Yes.
say hello to your lovely assistant and continue to take care of yourself.
Share the boss. She the boss.
The assistant baby, sir.
Yeah.
All right, take care, brother. We'll talk soon.
Great.
All
Yeah,
right.
Okay, great,
Yeah.
great.
All
Yeah,
right.
what?
Yes, people. Well, there you have it. Everything that you wanted to know about this case, it's there. You can go back and review. And I think that the judge overlooked it when it says the election court shall, within 6 months of the date of the taking of a poll, determine all matters brought before the court. So if it was never brought before the court, then the 6 month period doesn't pertain. And then there are other clauses in here that a strict reading would tell you that what the judge did. And I mean, again, you have to, you respect the opinion, but you disagree with it. You respect it, say, okay, the judge listened to the matter and the judge wrote an opinion. Fine. But you can take issue with it. And so there you are. Patricia DJ say our cousin of Wildman. Okay. Oh, so Wildman, if you're watching, you have a cousin, Patricia. So all right, folks. 7:55, 5 minutes to go. I cannot believe the time just flies so fast. We didn't get that. We didn't even finish up with Minister Vaz and the JPS and the annual report, because the annual report, people. That's gonna take
Just starting. That is just starting.
There's so much inside that annual report that'll just make your head spin. That when you listen and you read the stuff in the annual report, you'll ask yourself this question: why is the Jamaican government loaning JPS 150 million? You're gonna ask yourself that question because there is no reason to loan them 150 million. There's no reason. Remember now, them get 50 million from taxpayers, Whenever I'm sure you the phone bill where it says miscellaneous, and the miscellaneous is almost as much bill as a light bill. How many of you in Jamaica with a light bill look at the miscellaneous section and ever ask yourself, what is miscellaneous? And why it's so expensive? What is miscellaneous and what is so expensive? These are the things that you have to think through, my people.